Danger, hijacked buildings, criminality. When safety is on the line, courts can move fast, but only under PI Sections 5. I'm Simon Dippenaar, attorney at SD Law in Cape Town, Johannesburg and Durban. I've handled urgent matters where lives and buildings were at risk. And in this video, I'll show you what truly counts as urgent, the legal test under Sections 5, the proof you'll need, and common mistakes that sink cases. Now, Section 1, what urgent really means. Imminent harm to people or property, such as fires, violence, structural danger, hijacked buildings or entrenched criminal activity, serious ongoing prejudice that can't wait for the normal timeline, not just arrears or inconvenience. Courts will reject manufactured urgency. Now, the legal test under PI Sections 5. To succeed under Sections 5, you must show on affidavit that there's a reasonable possibility of irreparable harm to either the owner or the affected persons if eviction isn't granted urgently. The hardship to the owner or others exceeds the hardship to the occupier if an urgent order is granted. There's no other satisfactory remedy, and the occupier is unlawful. There's no valid defense that should first be ventilated on a normal timetable. Even then, the court still aims for an outcome that's just and equitable. Now, the procedure and the timelines. Under Sections 5, the court can abridge the usual time periods. Practically, you still approach on papers, the founding affidavit and annexures. The court can give directions for service and shortened notice. Municipal involvement is still relevant where vulnerability or homelessness is at stake. And orders often include clear vacate dates, SAP's share of support, and sometimes temporary accommodation where appropriate. Now, evidence that convinces. Incident logs. Dates, times, SAP's case numbers, security reports, photos or videos of fires, broken risers, compromised exits or violent incidents, expert letters for engineer or fire safety where structures are unsafe, neighbor affidavits for noise, threats, drugs or assaults, hardship comparison, why harm to owner or others exceeds harm to occupiers, what alternatives exists in any municipal contact. What's not urgent? Simple rental arrears, ordinary holding over, or frustration with slow process. If Sections 4, the normal route, fits you, you must use Sections 4. Trying to force Sections 5 will waste time, money, and credibility. Now, the typical outcomes. Where urgency is proven, courts may grant accelerated eviction with short but humane dates, direct the sheriff or SAPs to assist, include conditions, for example, cooperation with the municipality for vulnerable people. Courts often set a return date to monitor compliance. Now, what to do next? If you think your matter is truly urgent, don't guess. Get the evidence in order and get advice. If urgency isn't justified, we'll take the standard Section 4 route and keep the case moving lawfully. Download my free eviction playbook, the 7 steps, documents, timelines, and traps. If there's danger or criminality, book a consultation with SD Law today.